Have the tenants. All right.
Hey, folks. Thank you. I think we had a little mix up in time, but I think everybody's here. And I'm almost afraid to ask, where are we?
Well, yeah.
Go ahead, Mr. Freeman.
I was just going to say that there has been significant progress made. There's been some, I guess I'll say, stumbles along the way, but significant progress is being made, I think, on schedule. The fire doors that were in question did arrive, are being installed. There are some issues with inspections and building permits that need to be ironed out. I don't believe any due to any fault of the property manager, but my co-counsel has been very actively involved dealing with the property manager, communicating directly with the property manager, and I think is better prepared, informed, I should say, really, to address the issues that are still remaining. But that being said, we do believe we can meet that schedule that was set previously.
Yes, Your Honor. Ms. Ellis indicated fire doors are ordered. As you know, we submitted the plan to you at the last hearing.
Yes.
There were a number of permits that the city was requiring the property manager to pull. Those have been pulled. My understanding is on May 2nd, there were 13 building permit inspections scheduled. 12 of them were passed on that day. There was one that did not pass due to I believe the drywall not being painted at the time. But the
Drywall not being painted.
yes, the drywall. Yes, so the 13th one failed because the drywall was not primed yet. FDIC, the vendor, had a hard time getting the mud to dry with the tenant taking a steamy shower, so it was not able to be painted. They requested to have a photograph of it being primed, sent to the city within maybe, I believe it was like 30 minutes after. They were told that they could not do that. So they had to reschedule it for a new inspection, which I believe, Stuart, was that new inspection done?
It's on for this week.
Okay, so that new one is scheduled for this week. There was the scope testing that was to be done on areas. They received a proposal from TEK Environmental. The proposal was executed by the ownership, and they're just waiting for scheduling for that from TEK. So that is in the works to be completed.
Okay.
There were 2 items with electrical permits for 2 of the units in 721 Clark. The property manager is hiring LR Rolls Mechanical to pull electrical permits and schedule those inspections. Similarly, with a ceiling fan that was in a unit within 721 Unit 206, LR Rolls is being hired to pull the electrical permits for that as well.
But those electrical, they haven't been pulled as of yet, but you've hired somebody to.
Yeah, so the idea is that the company comes in and pulls the permits during that process. So they're working on hiring LR Rolls to do that. There was also, there's this boiler boiler letter and baseboard covers. There was a request by the city that we provide them with a boiler letter. Basically, that would attest to the fact that boilers are in working condition. The boiler letter had previously been sent to the city on March 17th, April 8th, and April 29th. We received a correspondence from the city on the 29th saying that the letter needed to be signed and dated per building, and that the letter did not have the building addresses on it. And so a new letter was provided to the city, and it was indicated that the signature was not a wet signature on the letter, and that the person doing the inspection is not the license holder. So we're trying to get in contact with the contractor so that they can communicate maybe with the city directly to get them what they need. But it seems like.
So the 3 boiler letters, are those for 3 separate boilers?
I believe that the company came in and looked at all of the boiler covers, or maybe Mr. Beal could speak better to this. Can you speak about boiler letters and what that is?
This is one of the last remaining issues that are gonna cause a problem on, May 20th. The city is requiring a letter from a licensed boiler contractor, to say that the boilers are operational. We provided that letter 4 times over the last 45 days, and it still has not been accepted by the city. And so we're asking the city to accept it in its, most latest, iteration. But one of the problems is that the boiler system is very expansive and complex. It has 24 apartments in each building, and there are radiator covers in each apartment that Jerry, the inspector, says if they're damaged, they need to be replaced. But
Well, I don't need to know what the problem is. What I'm trying to figure out is the letters that were sent. Were those encompassing all of the boilers for these particular units, or what were they?
so there's one boiler per building, and we've provided 1 letter per building now.
All right. Okay.
So as Mr. Beal indicated, this is going to potentially be an issue coming on the 20th. Because the position is that they want all of these baseboard covers that deal with these boilers replaced. And that is going to be approximately, I believe you said, about $20,000 of building. And so to the extent that this letter is saying that these boilers are operational, the property manager and the owner are saying that they will replace the boiler covers that are the most damaged, obviously, but to the extent that they're still working properly, it doesn't seem reasonable to require them to replace every single baseboard cover in order to pass this inspection on the 20th.
And to be clear, the city is not requiring us to replace every baseboard cover, but they're not telling us which baseboard covers they actually want replaced. So that's why it could be an issue on the 20th. So the city should either let that go or tell us.
Why don't you sit down?
Thank you.
You don't need to tell them what they need to do. All right. Okay, go ahead.
Also, the city was requesting a letter regarding pest control. It's my understanding that we have that information, and if it hasn't been provided to the city, the instruction is to provide it today. I believe that I saw it at the end of last week, so that letter will be provided to the city.
Indicating that somebody's been hired to do it, or that it's been completed.
It would be the contract for the pest control, letting them know when they're coming out, how often, services, things like that. So that'll be provided to the city as well. And then as Mr. Beal, I think, indicated as well with regards to inspections that are happening at the property. Another issue that we've run into recently has been scheduling the inspections and having the city come out to do the inspections. We're requesting inspections for several buildings on certain days, and the communication that they're receiving from the city is that you have this window, we're not calling, we're not going to the office, we're not asking for anybody, somebody be at where they need to be when we arrive. And if we've got 15 buildings scheduled for inspection one day, we don't know where the city is going to come up. So we're dealing with those kind of issues where they're refusing to communicate, and time is of the essence at this point. Everybody at the property is valuable, so having multiple employees camp out for a 4-hour window potentially to see whenever the city arrives, as opposed to a brief phone call, I'm on the way, it's becoming a bit problematic. So we're hoping that permits, to the extent that any additional need to be pulled and inspections need to be done, that this is not going to delay the process. So that's just something we wanted to bring to the court's attention as well, because that was specifically occurred with regard to those 15 that we had scheduled for May 2nd. So.
Okay.
Outside of that, I think that those were the main issues that we wanted to point out with regards to the plan and the progress. There also has been a request for 2 special inspections to occur this week, with regards to drywall that needed to be removed. So just in the process of getting the work done, drywall was removed that, they didn't anticipate being removed. So they're requesting special inspections to occur this week so that we can ensure that we're on track for the timeline. There has been no response to that request as of yet, but that request has been made to the city. And that would be the primary things we would want to flag for the plan. We do have a copy of the most current list of items from the correction order that were ongoing from the city, which we can provide to your clerk via email.
Yeah.
It gives a layout of what's been done and then also kind of the plan for getting those things done by the 20th. I just received those, so I don't have a printed out copy, but if that's something the court would like, we can make sure that
Yes,
that's emailed to you all. And that is the ones for 720 and 721. So we can make sure that the court has those.
wonderful. All right.
Yes, Your Honor, I had a chance to speak with Mr. Myers about all this, and it does sound like there's some progress being made, but it sounds like because of the fact that they're inspecting the other buildings at the same time, as well as other properties that Beal owns, that they haven't had the chance to get to where they need to be, where they think they're actually going to be on time to make it to the original schedule. I think about half the inspections they've been
What
doing
is that?
About half the inspections they've been doing on the Beal properties or on the Arbour One properties have been for other buildings that aren't these 2 buildings in question. So for that reason, they haven't been able to meet all the requirements that they have to for all the inspections. But I think Mr. Myers should probably speak better about this than I can.
Yeah.
Yeah, over the last 3 weeks, we have done about 73 inspections at Arbour One. 38 were on these 2 buildings, so roughly half. 16 were approved, canceled, or not ready, disapproved, so they're failing a little over 10% of all of these inspections. They're scheduling inspections for other properties that Mr. Beal owns and not these buildings, which is taking up our inspectors' time away from being able to inspect these buildings, to where next week we have 5, or this week we have 5 open inspections, 1 on Tuesday, 1 on Thursday, and 3 on Friday. The special inspections that they requested on Friday at the end of the day are for times that we don't have inspectors working or that we don't inspect. Because they asked for 1 on Friday at the end of the day at about 4, I think, and then Monday at the end of the day when we don't have an inspector. So we have 8 permits scheduled for this week to be done. There's about 20 that needs to be done. And so we have done whatever we can to make this happen. As far as the inspection, we give everyone a window. We have been told that we treat people differently, but we give everyone the same 4-hour window for inspections. And then we've also said on several occasions that we're going to always start at 721 Clark. It's the first address. That's not good enough for them, but that's really what we can do. But yeah, it's very concerning that out of
What's not good enough? What do you mean that's not good enough?
so they would like the exact time that we're showing up, when we really don't know when that is, because the inspections happen all throughout the city. But yeah, so this week we have 16 or 14 inspections scheduled for Arbour One, but only 8 of them are on this building, these 2 buildings. So seems like they're prioritizing other buildings over these 2 buildings.
Why do you say that?
Because if these 2 buildings are the only concern, which we've been told in an email from Mr. Beal that the city's only concern is approving these inspections, they're prioritizing other buildings in the complex
Yeah, but
permits.
what's gonna happen is that if they don't, I don't know if that's a prioritization. It's that this is sort of an ongoing concern.
Mhm.
So if I'm working over here, because that may be my next phase that I'm going to try to get some things done, then I would be trying to do them both at the same time.
But we only have a limited number of inspections we can do in a day. And so by taking them away from these two buildings, we're being pulled from those two buildings.
Okay. Regarding that,
Your Honor, if I may, I find that statement incredibly problematic because if we weren't doing work on other buildings, I mean, property's actively being cited by the city and other buildings as well, so we're splitting time, and I don't see that as a problem, but as Mr. Myers indicated, majority of those requests were for these two buildings. So, also, last hearing, Your Honor, you were inquiring with the city with regards to, I guess, the third-party contractor that comes in and does certain permanent inspections and things of that nature. So since that hearing, we have spoken with one of their representatives, Jeff Haber, individual who does the building permanent inspections typically for Arbour One. And he's indicated to us that he's having to find other work because the city is not keeping him busy enough. And because Jerry Dunham is now doing all of those inspections. And he's a little.
hold on a second. So this is a third party person to do inspections. That's at least telling you that he could do more, but that he's not being requested to do more.
Correct. He's Jeff Schaefer.
Stop there for a second. What, do you know anything about that? Huh?
No.
Okay, go ahead.
Yeah, our property management team spoke with Jeff Schaefer, who is an employee of Code Enforcement Services, CES, the company that the city contracts to do the building inspections. Jeff indicated that he's not being kept busy enough with the work now and has to reach out to others, get work from other municipalities because Mr. Dunham is now doing the inspections that he previously did. This is, on top of the scheduling, this has been an issue for us as well because working with Jeff, the process was, streamlined. We would do the inspections. He would give us yellow cards, letting us know the inspection results, and we would be able to, continue on from there. We now have Jerry doing those things. We're running into the, we're not answering the phone. We're not letting you know when we're coming. We're not calling, as well as you're not giving us inspection cards. So we have no verification at a certain point to establish whether or not we passed, which is problematic from a property management perspective. With the city coming out, we want to be able to verify when an inspection is passed and when it's not. So at this point, their position has been that they're not required to give them, but up until this point, we have always received them from CES. So just something we wanted to flag with the court as well, because these are things that are.
Well, hold on. Can this guy do more inspections?
So there are, per our contract, and
Whose contract? With who?
the city and CES,
Okay,
we can do 6 inspections a day. We have done more than that over the last 2 weeks, and we have yet to,
with this company?
with both with Jerry and this company, to make sure we get the inspections done.
All right, get on the phone right now, find out how many inspections he can do in a week. Let's do it right now. Because this doesn't make any sense to me. If somebody can do the inspections, then let's get them done.
Another issue I was hoping to bring to the court's attention.
Sure, go ahead.
So some of the tenants that have been relocated both in and out of court to the township side, they've continued to escrow their rent. And now they're receiving 7-day notices to evict them. One of those people, Miss Natasha Drake, is in court today. And
So
Received it last Thursday.
she's received a 7-day notice. But they're on the township
On the
side.
township side, but she's been escrowing her rent
Here.
in this case, yeah.
Okay, and, and she's escrowing it on her case, right here, right? Okay, so, just so that you know, and we haven't quite worked it out, Judge Washington is aware who would be handling the township cases. She's aware that the escrow is being paid here. How exactly that financial mechanism is gonna work? We're not sure. Is the rental amounts the same? Or, well, that's gonna be the part of the issue. The other part of the issue is who's going to be paying for that relocation, which is another issue. So,
That's, that's a twofold issue because of course we had our hearing with Judge Funky last week on our preliminary injunction motion, presented by the city prosecutor. That has not translated into an order yet for various reasons. However, she addressed the issue of rent payments, relocation of tenants. She's made clear that tenants who are requesting relocation assistance can speak before her on 3 days' notice.
can do what?
Can appear before her with a motion on nearly 3 days' notice.
Okay.
She did reserve the issue of various things like emergency repairs, health and safety related repairs for a hearing. Was originally scheduled for 6/6 inexplicably. It appears that hearing has been moved to 6/20. Any tenant desiring to be relocated is to receive a 100% refund of all of their escrow funds, all of their paid rent from 9/17. So that would affect obviously the escrow order of this court once her order is entered, and also the escrow.
They're to receive what?
They're to receive a refund of all of their rent paid from 9/17 if they paid rent
From 9/17.
9/17 of 2024, which was the date of the suspension of the certificates of compliance. And that they would be prohibited from seeking to collect rent while there are no certificates of compliance, because that's explicitly what the ordinance requires. It also prohibits leasing of buildings at the Arbour One property on the city side. Also prohibits all rent collections, as I believe I just said. And so she's looking at relocation on a case-by-case basis and addressing the
Has the,
refund of escrows on a case-by-case basis.
well, I'll wait to see her order on that. Then deal with
There's a
it.
lot going on, obviously. I'm not sure what you were aware of.
Mr. Henry, so what's gonna end up happening is even if it's gonna be a bit problematic returning escrows because the escrows may need to be paid, or at least these people could end up being relocated to the township side. And now you've got basically 3 courts with their hands in it, trying to figure out what to do. So I think between the 3 of us, we'll be able to figure it out.
You said Ms. Drake was.
Ms. Drake is one. I believe there was also Mr. Blankenship. Then there was some that were not in court, like Alina Jordan, Lawrence Grove, and Weena Harris Freeman.
And these individuals have all been relocated to the township side?
They were all originally on the city side, relocated to the township side.
Okay. Township side has COCs. So
Correct.
why are they still escrowing their rent when they're in a.
Because they wouldn't be on that side, but for what's happening on the city side.
I think another issue is they were relocated, given new leases, so they don't know if they have an increase in rent, a decrease, or if it's the same as previously. Some of them have leases that are ongoing, some the lease expired, so they've just been escrowing the same amount that they would pay either to the court or to the city.
And I mean, that's,
I don't need, Mr. Beal, I don't need your comments. Go ahead. What were you gonna say?
so the court has ordered that even if they're on the township side with COCs.
I've ordered them to comply with my escrow order.
Okay.
And where they can either do it to the court or to the city. Because the question really is gonna be, if they've been relocated, do they intend on coming back, or should they be paying for where they are? And I guess maybe the way to look at it is, it's one thing if they're in a new apartment and one can look at that in one way. Or you look at it from the standpoint that if they were placed in a hotel, then would they be paying the hotel bill? No. Right? So is this temporary? And I think and Mr. Henry, you can correct me if I'm wrong, but the real question is there relocation to the township side a temporary solution, or is that a permanent solution that at some point that's where that person's going to be?
Right, and I think that's would kind of speak to the answer to his question, is to speaking with all these individuals to see if they intend to stay in the township side, or if their intent is to, again, be relocated back to their unit. If they intend to stay, then I think that conversations to be had about whether or not they should be paying rent.
Well, and whether or not they have a lease.
Right, and then,
I mean,
you know, further.
I would agree with you in that respect. But remember how this all started. It all started because the units on the city side were not in compliance. So these people had to be relocated. The people get relocated, and some of them are put in hotels, some of them are put in other units, with no clarification as to the permanency of any of that. So.
If I may, Your Honor, it seems if somebody's been relocated to the township side in a certified unit, they are certified. That and they wish to stay there, they like the accommodations, and are willing and able to sign a lease or a lease extension that rent should resume. It's there's no health, safety, or certification issues that would preclude the landlord from requesting rent for a certified unit that the person intends to reside in.
If they have a lease.
Yes.
But I don't know if any of these people have leases.
That's my understanding, that they don't have leases. Ms. Drake, is that correct, that you don't have a new lease?
I'm sorry,
That's correct.
you don't have a new lease. Yeah. So, I mean, ultimately, the real issue is, are they intending on staying there? Have they moved, or have they, I guess, for lack of a better term, have they relocated or have they moved?
Right.
That's really going to be the issue, as far as I'm concerned. But
And we can, obviously, I can communicate with legal services about having those conversations to see if some of these issues could be resolved. Because I think that, you know, this turns on a few of those questions that I don't think anybody has a clear answer to at this moment. So what the intent of the tenants would be.
Do we get an answer regarding the inspection?
So not quite, but I have an answer that I think will satisfy. We have not denied any inspection at this point. We are running out of time for the 20th. But we have made it work. We might not be able to make it work with the timelines that they want, like end of day Friday and Monday when we don't have any inspectors. But we have yet to deny one inspection. And so
I don't know that that's what I asked.
and I have sent back to our company that does it. And so
Pardon?
I have a call in and a message to call me back because I'm in court, but I have not gotten a call back from CES.
That really dictate in certain respect whether or not the 20th is gonna be able to happen.
And their boots on the ground are telling our boots on the ground the 20th isn't gonna be happening.
What?
So even our boots on the ground are hearing from their people that they're not likely to make the 20th. They're only pulling permits on certain things. Even last week, as you heard from them, there's certain permits that haven't even pulled, they haven't hired the person to pull them. And that's been 2 weeks ago that they agreed to pull those. So with issues, the city's not the problem here ultimately, Judge.
Well, I think everybody's a problem. Because what I'm hearing is I don't think people are communicating. I think people are getting in certain ways for whatever the reasons are. And that's fine if everybody wants to act that way. I mean, I certainly will let Judge Kunke know what I am seeing on my end, regarding that. But, you know, if, I mean, just by way of example, if one side is hearing that somebody can do more inspections, but for whatever reason, those inspections can't be done, that doesn't make any sense to me. I mean, it's like we're talking everybody's talking two different scenarios here, which makes no sense to me.
Meeting we had here a couple of weeks ago, they asked us to attend, and one of the items that came out of that was insistence on our part and agreement with theirs. There would be a single point of contact. So we didn't have this, he said, she said folklore, from whoever it's being spoken to. We identified who we wanted to have as our single point of contact. And it was our understanding that they would do the same. And, when there's a disconnect like that, again, that we try to address.
How many inspections on 720 and 721 are there this week? Pat?
8.
That's all that's been requested.
Yes.
Is that correct, Council?
That's all.
That's accurate.
Yes. 8 have been requested. 8.
You said you had the punch list of what needs to be done.
Yes, I have 2 documents that are the rental inspection correction notices, one dated April 3rd, one dated March 31st. And this appears to be the most recent list, and it's laid out by what's been done, and then notes from the property management team as to plan to get those things done by the 20th. So yes, I can email that to Anne.
Okay. And I guess my question is, that list, is everybody operating off of the same list?
Yes.
I think so, yes, Your Honor.
Really? Are we,
I think
So-
it's a city correction order list, so we're working, yes.
is that the latest one? All right. And so the object is to get what's on that list done by the 20th.
Yes.
All right. Mr. Henry, was there anything else?
I don't believe so, Your Honor.
So the issue regarding the working out who's gonna be where, how's that? Are you just gonna reach out to legal services and try to resolve some of those things?
I'll communicate with, legal services and we can see what information they can provide us regarding the tenants as to their intent to stay or go. And then from there, I think we can have conversations on, leases and things of that nature.
And if you have a list of who received those 7, 8 notices, we could probably try and reach out to many of those we can to see what their, preference is or what their plan is.
Make a note to, I don't know that I'll see this week, but I'll touch base with Judge Washington just so that she's, or Magistrate Bailey, just to make sure they're aware what potentially could be coming down the pipe on those. Those, and I don't know if you can, if anybody can answer this, those cases would be filed in the name of Arbour One or the village. How would those cases be filed in the township? Mr. Friedman, do you know?
Mr. Beal's using his other his regular landlord tenant attorneys for that, Your Honor, and I'm not involved.
Got it.
I'm not aware of it either.
Okay. Then I'll let her know that I have no idea, but they're there. Okay.
Once we establish, whether or not tenants intend to stay on the township side, to the extent that they have been escrowing their rent while on the township side, is that rent then being released as rent to the property?
Say that again.
So tenant A been on the township side, been relocated for a month. There's a COC over there. We set up a lease with this tenant just to kind of establish what's going on. She escrowed her rent for that month. Is that rent now being released to the property?
Okay, so here, that's gonna be a complicated answer. Because theoretically, if there's a case filed at 14B, okay, on the township side, my preference would be to release the funds to 14B court and then let Judge Washington make that determination. If there's been no case filed, and this is where it's really gonna get sticky. My feeling would be that once all of that's worked out, then somebody would give me the numbers to just figure it out what needs to go here and what needs to go where. That would be my preference. But what's now being indicated is that there may be an order coming down from the circuit court that all the money's to be given back to the tenant, which means that anything I then have would have to go to the tenant to do with what they need to do. Now, I would seek, quite frankly, to try to get a clarification from the circuit court, or have somebody do that, get a clarification from the circuit court as to, in those instances, what should be done.
think the circuit court order also is a caveat that these monies are being returned if the tenant decides to break their lease and leave. So,
Oh, well, that's wholly different.
right, so
What?
That was the point that Ed brought up.
So, okay, but let me ask this because I'm not sure how one would interpret the order. Is relocating, but then the tenant makes the decision, I'm gonna stay I'm gonna stay now at this new place. Based upon what's being said, that money, the monies that would be held here go to the tenant and not to the landlord. Or is that not your understanding?
I don't think that would be my understanding. I think the tenant relocating. I think we're confusing two issues right now. So.
Oh, I'm not confused, but go ahead. No.
I think that there are some things with Judge Simpsons' order that are very clear. I don't think there's any dispute that it was decided that if a tenant decides they want to leave and break their lease and leave, that they can do that. There's no issue with them breaking their lease and leaving.
And that's really the breaking of the lease.
Right. So.
But a relocation does not fall in that category.
Right. That's where I was meeting. We were confusing two issues. So a tenant can decide they want to leave. They can break their lease. Arbour One is not going to object. If that happens, they can be refunded money that they paid in escrow.
Got it.
They can be refunded rent that's been paid since the CFC period until the time they vacate. And then I believe that they would be returned a security deposit if they paid it. If they decide to vacate and leave. And
got it. Okay. Was there any?
Is that your understanding as well? I just want to make sure. That seemed very clear.
So it was more of a emergency motion, so as to help the people that were still located in the condemned units to get out as soon as possible.
Correct.
I think that's why it was specific to those people.
Got it. That makes sense. Okay, so now to people who, and again, I'm going to have to see the written order, but to people who are relocated, but then elect to stay, which was basically what Mr. Henry had brought, elect to stay where they've been relocated to. What's supposed to happen with their escrow? And please don't tell me it's silent on that.
I mean, the order did not speak to individuals receiving any funds back unless they were electing to break their lease and leave. So if somebody was relocated, I don't think that this order spoke to whether or not they would be entitled to any of those monies back.
Okay, and let me just say this. Based on what's explained to me, that makes sense, right? However, and I'm just talking technically, but it's not my order, so I don't know how to interpret it. Somebody being relocated, and then the conversation occurs, I'm going to now stay where I've been relocated. By definition, they then break that lease or that tenancy that they had. And so if that's the interpretation of that, then they fall into that same category. Just thought I'd throw that into the mix. But I don't know if that was the intent of what Judge Conkey was ordering.
Cannot speak for Judge Conkey, but my understanding of the hearing is that was not the intent. It was only specifically pertaining to individuals who are currently at the property on the city side who want to break their lease and leave the city side.
That may be a fight for another day. It just, because it just has to be some clarification on that, and that's gonna part of, as I see it, somebody somehow or another there's gonna have to be some clarification of that, because what's gonna end up happening is at some point the folks on the township side are gonna file a case. And then it's gonna be sort of one court, 14A may have the money. 14B has a case looking for the money. And the circuit court has issued some order. So somewhere along the line, that has to get clarified rather than everybody scrambling around trying to, at the last minute, trying to figure that out. Bless you, it seems to me. So, anything else we need to, now that I have this update, anything else we need to do prior to me giving the next date?
Your Honor, Todd Ryan appeared by Zoom. Permission to speak briefly?
Yes, go ahead.
So Todd Ryan, P81848, representing plaintiff prosecutor in the circuit court matter, not a party, speaking as a friend of the court, and informed the court regarding that recent conversation about the scope of the order. That is going back before Judge Conkey as to what exactly was ruled and was not ruled. Both plaintiffs and defendants have submitted proposed orders to the court for the court to finalize. But it was very clear on the record that it did not involve township properties, that the judge was focused, because that's what we presented on the city side. And for the city side, the judge did orally rule that there wasn't a basis for escrow on the city side with the lack of the C of C. But that was purely for the apartments, and that was kind of a necessary precondition to not ordering escrow on the city side alone. Again, that'll be going back before the judge on some other hearings on Wednesday, so it's very possible the judge
Not ordering escrow on the city side. I don't. Okay, that's fine.
And so with the unusual procedural posture here, with plaintiff prosecutor not being a party before your honor, and their separate claims for the prosecutor than for the tenants, I understand trying to get ahead of it and making the order as consistent as possible. But as I believe Counsel Henry said earlier, this was in the context of a preliminary injunction for emergency relief. And we're going to have a more protracted presentation regarding where the money should go out of that emergency context.
Okay. So are you telling me the circuit court has vacated my order?
No, Your Honor. The circuit court orally found that she would not order escrow on that, and there wasn't a basis to do that for what was presented to her. And she did orally say that the tenants could submit this to district court and to the city of Ypsilanti for that court's consideration. But Your Honor, that may not be reflected in either proposed order.
Of course.
And I do have a recording of the hearing available, but to the extent, just thinking out loud here, to the extent Your Honor had questions to present to the circuit court because they impact your case, I wouldn't make a suggestion on that for Your Honor.
That what? You do what?
Oh, I don't want to make a suggestion to Your Honor about what would be helpful for you. I was thinking of the context of like a certified question, but you know, this is a very different kind of procedural posture with a district court and a circuit court with different parties before each court.
I just called Judge Cookie. I had to try to figure it out. And then once I see a written order, I mean, I don't think on either end. And I would hesitate to say, not speaking for them necessarily, but with Judge Conkey, Judge Washington, and myself, I don't think anybody's trying to make anything complicated. It's just we need to know what to do. And so that everything is consistent. So, and sometimes that would not be the attorney's objective, but I think it would be the judiciary's objective. So, all right, thank you. All right. Did we get a call back on that inspect? Okay. So prior to our next date, I want an indication regarding these inspections so that, and if who is it, CES, if they're willing to put something in writing saying that they can do more inspections, I'd like to see that. And I guess I should clarify. Are they willing to do more inspections and how many can they do a week?
And what's the cost?
Well, we'll figure out the cost. I mean, if somebody's got to put some money in there, what? But if somebody's got to put some money in there, look, folks, here's where I'm at with this. And just how I am. I don't like people coming here telling me why you can't do something. Find a way to get it done, and then let's figure out the nuts and bolts to achieve the objective. Because I'm hearing a lot of sort of naysaying coming from both sides about why we can't do something. And that doesn't make any sense to me. Right. So you guys are looking to have this done by the 20th, which is a Tuesday. And let me ask you this, there would likely be, if you're trying to get everything done by that Tuesday, there would likely be inspections that would be happening that day, is what I'm thinking. Right. So I don't. Maybe the next day would likely be the 23rd, which is a Friday, but what do I have on that?
Let me run.
I mean, I could, if I, it's Friday.
Second grade. But you're correct, there's 70 second grades this week on Friday.
Say again.
We have 70 second hearings on Friday this week.
Okay, so, but the 1 week adjournment from the 16th is going to happen, but those have become second hearings. So here's my thought. And it's just a guess. Is, have we set 23rd first hearings done?
Yes, we have.
What do those blocks look like?
And 15 second hearings at 10 a.m.
No, those aren't second, those are first.
Yes, 15 first hearings at 10 a.m.
All right, so here's what we're gonna do. Set this on the 23rd at 11 a.m. Okay. And council, so that you know, I know we had a bit of a delay, but I'll set it at 11 a.m. on that day. Oh, that's not gonna work for Mr. Freedom.
Well, Your Honor, I finished.
Oh, okay, fantastic. Okay.
I got a certificate of completion.
All right, fantastic. Congratulations on that, my friend.
Thank you.
All right. So we'll set it on that day. Okay. And then that way we'll see, and I will just let council know you'll be here in person. I will have Zoom hearings going all over the place that morning, but I will try to get them out of the way and make it as least convenient for you as I possibly can and get you in and out. Okay.
I will be back in town.
Pardon?
I will be back in town for live hearings.
Yeah, I'm seeing that nice sunny sky behind you.
Yep. It's real.
Okay. All right. Was there anything else from either side then?
No, Your Honor.
All right, thank you. You're gonna get that list to me.
Yes.
We can see where we're gonna go. And I want an update sent to Ms. Weidling regarding that CES inspections.
Okay. Yes.
All right. Okay, thank you, folks.
Thank you,
14A stands in recess.
All right.